This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about a case where no defense is available to an insured for economic damages alone, and if there is no bodily injury, no property damage, there is no coverage. In Westfield National Insurance Company et al. Versus Quest Pharmaceuticals, a United States Court of Appeals Sixth Circuit decision of January 13, 2023, suits against opioid manufacturers and distributors for expenses incurred by cities or other governments were rejected because the plaintiffs incurred neither bodily injury nor property damage. In the wake of a nationwide opioid epidemic, aggrieved individuals, local governments, and other organizations are taking pharmaceutical companies to task for their allegedly wrongful conduct in promoting and distributing prescription opioids. Quest Pharmaceuticals Incorporated, a Kentucky-based distributor of generic drugs, now finds itself on the receiving end of approximately 77 such lawsuits. Quest reported the litigation to its insurers, Westfield National Insurance Company and Motorist Mutual Insurance Company, who promptly sued in federal court and sought declaratory judgments that they were not required to defend or indemnify Quest in the underlying lawsuits. The district court granted summary judgment to the insurers, reasoning that the relevant policy language did not cover the claims brought against Quest. The underlying plaintiffs pleaded violations of the RICO Act, violations of state statutes, and common law claims of public nuisance and negligence. The underlying plaintiffs' damages included significant expenses for police, emergency, health, prosecution, corrections, rehabilitation, and other services. Many of the complaints also clarified that the plaintiffs' claims are not based upon or derivative of the rights of others, and that the plaintiffs do not seek damages for death, physical injury to person, emotional distress, or physical damages to property. Given that the court found that the policies did not require either insurer to defend or indemnify Quest in the underlying litigation, it never reached Westfield's alternative argument that the policy's known loss provision, which excludes injuries the insured knew of before purchasing the policy, also precluded coverage of the underlying lawsuits. In the end, it didn't matter. Regardless, the Sixth Circuit, analyzing the issues, as a federal court sitting in diversity, applied Kentucky law to the question of contract interpretation. And in accordance with Kentucky law, the Sixth Circuit was required to interpret the policies according to the parties' mutual understanding at the time they entered into the contracts, based solely, where possible, on the plain language of the contract. Broadly speaking, terms in an insurance policy are given their plain and ordinary meaning, such that words with no special technical meaning in law are interpreted in accordance with common use and understanding. The policies here required the insurers to defend Quest against lawsuits seeking damages because of bodily injury, and indemnify Quest for any such damages that Quest becomes legally obligated to pay. An insurer's duty to defend arises whenever an allegation in an underlying complaint just might fall within the policy's purview. The underlying lawsuits seek damages within the meaning of the policy. They also agree, however, that the lawsuits do not seek damages directly for bodily injury. The sole disagreement is whether the damages sought are, quote, because of bodily injury, close quote. Generally, the phrase because of means on account of or by reason of. Quest argued that the underlying lawsuits are because of bodily injury, where they would not have been brought but for injuries caused by opioid abuse and addiction, and thus exist by reason of or on account of those underlying injuries. The insurers argued, on the other hand, that the claims are not because of bodily injury, where they fail to allege any particular bodily injury and seek only economic damages for costs the underlying plaintiffs incurred in addressing the opioid epidemic. In this case, the underlying plaintiffs seek economic damages not to compensate an explicitly covered injury, but rather to cover the costs of activities conducted in relation to many indeterminate injuries. As a result, the Sixth Circuit agreed with the district court that the lawsuits against Quest are not because of bodily injury within the meaning of the policies. The Sixth Circuit concluded that lawsuits brought by local governments and other entities to recover costs incurred due to the opioid epidemic, but not to recover for any specific bodily injuries, do not trigger the insurer's duties to defend or indemnify Quest. The parties agreed that the lawsuits alleged no particular injury to any particular person. The allegations instead broadly describe societal harms caused by opioid addiction, such as diminished productivity and increased healthcare costs, which the underlying plaintiffs tie to Quest's and other pharmaceutical companies' saturation of communities with prescription opioids, fueling illicit opioid addiction. As such, the underlying lawsuits against Quest are not because of bodily injury, and the insurers have no duty to defend Quest or indemnify it for any damages it may owe. The definition of damages likewise informed the Sixth Circuit understanding of the policy's scope and purpose, namely covering tort claims. Nothing in the policies suggests that they were meant to cover lawsuits like the ones here, brought primarily by local governments to recover purely economic damages. The plain language instead indicates that claims must in some way derive from a particular bodily injury to a person, although some of the complaints plead tort claims such as nuisance or negligence. The underlying theory of recovery is that Quest's alleged misconduct resulted in economic harms to the entities themselves. No complaint, not one of the 77, predicates recovery on a particular person's bodily injury, and so no complaint triggers the insurer's duty to defend. The claims, all of which are for economic damages, were, in the opinion of the Sixth Circuit, simply beyond the policy's scope. In my opinion, the Sixth Circuit read the full text of the policies and the allegations for the suits against the insureds and reasoned their decision as a result, finding no bodily injury or property damage claims, coverage for the suit seeking damages from the insured for costs the opioid drug infestation imposed upon various cities and other public entities were economic only. No damage from the opioids due to the insured against risks of claims of bodily injury or property damage, and since there were no claims of bodily injury or property damage, there could be no coverage for neither defense nor indemnity. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog, where you can subscribe to the blog and receive notice of every blog posting, usually one every 5 days of the week, sometimes 6. And you can also subscribe to the YouTube video or the Rumble video, which are available free to anyone who just asks. And you can listen to the podcast on any place where you hear podcasts by just seeking Zelma on Insurance. If you found these blog posts and the videos to be of use to you, please tell your friends and colleagues so that they can also subscribe. Thank you for your attention.